Good afternoon, members. I call the Committee of the Whole on Bill number 9, what were we doing? Miscellaneous Statutes Amendment Act, to order. And we are on Clause 57. Minister, did you want to open? No? So recognizing the member from Shuswap.
Thank you very much, Honourable Chair. Certainly, I'm very honoured to have the opportunity to make some inquiries of the Minister of Labour with respect to these pretty substantive labour code changes. Through Honourable Chair to the Minister, can the Minister share with this House what broad consultation was undertaken prior to the introduction of this bill?
Minister.
Thank you, Honorable Chair. Thank you for the question, Honorable Chair. I just want to begin by saying that in British Columbia, honoring the picket line of workers set up by workers themselves or other unionized workers is a fundamental feature of BC labor relations. And that was how it was understood. And it's been that way since early 80s or late 70s. And but recently, a labor board decision posed some questions to that fundamental right that the workers in British Columbia always thought they enjoyed. And because now the situation arose where there may be two different workers certified under two different jurisdictions on a same site. So one could be the federal, under the federal law, and the other one would be under the BC Labor Code. And with the narrow definition under the code, the Labor Board made a decision that if the picket line is set up by other jurisdiction, in this case it was a federal, then if the provincially certified employees were to refuse and honor that picket line, which they always thought they had the right, then they would be on an illegal strike. That posed huge problems for those workers. And these are we have to understand, these are workers who are on the same site, talk to each other every day, and there were cases where there may be family members, one on one side and the other one on the other side. Imagine going home under that circumstance, crossing a picket line set up by your family member. Great deal of difficulty. And as a result of that, we felt that we need to get back to make some changes to the definition of strike so that we could clarify clearly what the definition of strike means. That regardless of which jurisdiction a worker has set up the picket line, that the workers from other jurisdiction will have the right to honor that picket line.
Member.
Well, thank you, Honourable Chair. I don't recall receiving an answer in that statement. Look, it's very important legislation. It's a bit odd and very unusual for a change of this magnitude to appear in the middle of a miscellaneous statutes bill. But aside from that, I think it's incredibly important for the Minister to share with this House what broad consultation was undertaken in the preparation of this legislation.
Minister.
Thank you, Honorable Chair. So the situation, as I described in my first answer, was brought on by the Labor Board decision. And where we were, during this mandate, we may not have the opportunity, making changes if we go through the consultation as, the member is asking, inquiring about. We felt that we need to fix this uncertainty that has been caused and a lot of anguish and pain that was caused among family members, among different union members. And so we felt that we need to move on quickly and that we need to clarify the definition of strike, because workers always thought they had the right to honor a picket line established by themselves or other workers. And this Labor Board decision caused that confusion, and so we felt that we need to move on. Now, we have a Labor Code Review panel established, a member will know, and they would be taking submissions on Labor Code, any parts of Labor Code, any decision pertaining to Labor Code, labor laws here, including this particular one. And so they will have an opportunity to hear from both sides and all sides to see if this definition works, or they will come back with recommendations if something else needs to be changed. Then we will take a look at it at that time.
Member.
Thank you, Honourable Chair. So I take it from the Minister's answer, and I certainly stand to be corrected if there was any consultative work, but what I'm hearing from the Minister is that there's been no consultation undertaken whatsoever with respect to the tabling of this piece of legislation. This is very significant legislation. It is out of step with any other province and jurisdiction in Canada. The Minister, through Honourable Chair, the Minister makes the claim that somehow this legislative amendment to the Labour Code to allow for secondary strike action is somehow, the amendment is to clarify a position. That is not the case. The Minister is clearly trying to change the definition, which will put this piece of legislation in British Columbia out of step with every other province in Canada. So this is not just a small clarification or a correction. And the Minister references the Labour Review Panel. The Labour Review Panel is the result of an initiative of this government for a broad consultation to be undertaken across British Columbia every 5 years to help inform government and inform the Minister with respect to legislative changes affecting the Labour Code. But, Honourable Chair, while this work is being undertaken, while the panel is educating themselves and having an opportunity to hear from businesses and trade organizations around the province, the Minister has chosen to sidestep, to kneecap that entire process and move forward with this legislative change. So one more time, through your Honourable Chair, to the Minister, can the Minister share what consultative work has been undertaken to inform himself, his government, and his ministry with respect to the legislation that he has tabled before the House?
Minister.
Thank you, Honourable Chair. We heard very clearly from at least the Labour side who was impacted by the Labour Board decision. And we certainly, I think member would know, heard from the people involved directly. I will read it for record here. It was in the media. This is wife. I may want to keep the name out. She's a contract telecommunication worker, was ordered by BC Labor Relations Board to do work for Rogers Communications, Inc. after it locked out its employees in the Lower Mainland. For her, it was personal. Her husband was one of the workers who had been locked out. It's the worst feeling in the world, she said. Suddenly, she was spending the morning supporting her husband and his co-workers as they walked the picket line. Then in the afternoon, she was being forced to cross the picket line and do their job. And again, like I said, Honorable Chair, it is a worse feeling for a worker. A member may not realize the importance of a picket line and crossing a picket line. It's just the basic fundamental to collective bargaining and right to picket line and right to honor a picket line. So Labor Board, in their wisdom, made a decision, and the workers always thought that they always had their right. And it wasn't questioned until the Labor Board made a decision, because they believe that the narrow definition is the result of their decision, where two different jurisdictions, one is on a picket line, the other one now, if they honor the picket line, it will be considered an illegal strike. And no one wants to be in that situation. Consequences are huge. So, Madam Speaker, we heard from those families, we heard from the workers, we heard from the labor movement, and we believe that we need to move on now. But again, it doesn't stop the parties in a broader consultation that the Labor Board review will take, and come back with the recommendations if they believe this is the way the definition should be here in British Columbia, so be it. But if they come back with a recommendation, after hearing from different people, then we will take a look at that time.
Member.
Thank you, Honourable Chair. The Minister references a news article affecting one spouse who I'm sure was challenged with having to cross a picket line in order to meet the obligations that she was under with the collective agreement she was under with her employer. She was able to attend work. She was able to earn a paycheck, which I think is ideally what most people go to work for. Through your Honourable Chair, to the Minister, I guess in the absence of any consultation that this Minister has undertaken, can the Minister share with us how many workers in British Columbia will be potentially impacted by this legislation?
Minister.
Thank you, Honourable Chair. It's a principle that we are establishing through the definition of strike with Bill 9. But practically, there may not be very many locations where you have multi-jurisdictional units located on the same site. So may not be very many, but we know that there were some. There are real issues, there are real incidences, and it was such that it went to the Labor Board, and Labor Board made a decision, and it impacted those employees affected at those locations. But there may be some more, but this is the principle that the picket line is a picket line, and the workers always felt that they have the right to honor picket line by themselves or other workers, regardless of jurisdiction. And so that's why we are fixing this. And again, like I said, I'm looking forward to the Labor Code Review Panel's recommendations on this, and then we'll make a further decision.
Member.
Thank you, Honourable Chair. Look, I reject the characterization that this is fixing anything. This is creating a significant change which puts BC out of step with other province and every other jurisdiction in Canada. And the unintended consequences could absolutely be catastrophic. There's 500,000 unionized workers in the province of BC, 500,000. And the minister references one individual, and suddenly there's going to be broad sweeping changes. They're going to fundamentally change the way that the Labour Code is actually interpreted and affected in British Columbia, putting workers at significant risk. Look, Honourable Chair, the purpose of the Labour Code is largely to provide balance. And the instance that occurred back in 2022 with Vancouver shipyards, it was incredibly challenging for workers that were looking to actually go to work to generate a paycheck, to increase their pensionable earnings, to be, in effect, not able to actually go to work on account of the strike action. It put the employer at a significant disadvantage. The employer did everything that was right. They had a collective agreement that was signed. They had an agreement that was agreed upon by all of the workers that were working at that particular facility. And so for an unrelated strike action that might be at the same location, for that strike to negatively impact the ability of those workers to go to work, and for that employer to, in order to to carry on and fulfill their contractual obligations with their clients, it was wrong for it to be impacted. And the Labour Board conclusively came back with that determination. And then part of the ruling, it's about a 60-page ruling. In the one portion of the submission for consideration, it states the employer submits that the original decision that the Labour Board made, so the Labour Board initially came out with a quick decision which supported the workers' right to strike. On appeal, after later scrutiny and determination, they then found that that original decision was not valid. So the quote is, the employer submits the original decision is also inconsistent with code principles because it fails to consider Section 2F of the code, which requires the board to exercise its powers to perform its duties so as to minimize the effects of labor disputes on uninvolved persons. These are uninvolved persons. The labor law is clear that if there's a dispute or disagreement between an employer and the union that represents the workers, that they have an opportunity outside of their collective agreement to potentially take strike action. But these workers that we're talking about, Honourable Chair, did not have a dispute with their employer. There was no issues. They were in the middle of their contractual obligations under their collective agreement. And it was a separate federal union under the Canadian Labour Code that went on strike, only about 140 workers, I believe, that was potentially putting a couple thousand workers out of work for a period that stretched on for over 6 weeks. Where is the fairness in that exchange? The employer, Vancouver Shipyards, did not breach any of their obligatory or contractual agreements with their employees. But just the fact that they cohabitated a site with a separate union that chose to down tools and to take their employer, to take job action with their employer, somehow was going to affect these other 2,000 workers that did not have any complaints with their employer. And that's wrong. That's not fair. That's not balanced. It's not just. And this legislation is not in keeping with the interpretation of other labor codes across Canada. This is an incredible step that totally goes against the balance that was provided through the labor code. So, Honourable Chair, the minister has indicated there's been no consultation, zero consultation. And certainly I'm happy to stand corrected if there's been any consultation that's been undertaken. This is a very, very important piece of legislation. You can't undertake these changes lightly. All we've heard from the minister thus far is a report of one spouse who was concerned about crossing a picket line that was held by a company her husband worked for. There's 500,000 workers in the province that will potentially be impacted by this legislative change. We have business uncertainty. The competitiveness of BC companies has eroded significantly under this current administration. And here yet again, more uncertainty. And what is uncertainty? That adds to business risk and certainly won't help us with affordability. So through our Honourable Chair, I hope that the minister can share at least some level of effort that his ministry has undertaken to fully understand the broad implications that will be associated with the legislative change that he's brought before this House.
Minister.
Thank you, Honourable Chair. Look, the member mentioned quite a few times that somehow we are out of step with other jurisdictions. We are already out of step. Mr. Speaker, in British Columbia, labor laws in BC already allows provincially regulated employees to legally refuse to cross a provincially regulated picket line. Not every province has that. We do. Out of step, yes, but we believe that that is the right thing to do. Out of step, Mr. Speaker, Madam Speaker, minimum wage. We're highest of all provinces. Out of step, yes, but he said, right thing to do here in British Columbia. Asbestos protection. No other province has it. We do, because it saves lives. It is the right thing to do. That's why we're doing it. Single step certification. Card check, many called it. My colleague always card check. It is the right thing to do. Not every province has it. Madam Speaker, we should be leading when we are protecting workers and enhancing their right under the Constitution. Enhancing workers' right. And one of that right is a basic fundamental is picket line through bargaining and right to honor a picket line. I'm proud that we are a province where workers actually have that right. And member mentioned another thing. Somehow he is speaking on behalf of the workers, which he is not. One spouse. No, there were another 900 workers through their union, their reps. They're the one who are approaching us, not just one person. This member does not speak for the 900. This member does not speak for any unionized workplace, to be clear. And Madam Speaker, that's why we are listening to those workers who were impacted by the Labour Board decision. We feel that it is necessary to clarify what the workers' right are when it comes to honoring a picket line. They've felt since 1970 that they have that right. They have been exercising that right until it was challenged at the Labour Board, and the Labour Board made a decision that they did, that if it's the federally regulated employees on strike, provincially regulated employees, if they refuse to cross that picket line, it will be considered as illegal strike. It causes a lot of problem among family members, among friends, among those people who work together. And so I think that's why we have to move quickly. we're moving, and because we believe this is the right thing to do, we need to clarify what the confusion has been caused by the Labor Board. I mean, they made the decision based on the evidence that they heard, and I don't fault them. And but again, like I said, Labor Code Review Panel will be listening, taking submissions on this issue, and they may come back with different option to protect those workers that we are talking about here. But we will look at that when they come back, because they will have time, and they will have time to analyze after listening to all different sides what is the right approach. If this is the right approach, then they will tell us. If they believe there may be something else we need to do, then they'll tell us that as well.
Member.
Okay, Honorable Chair, the ministers has shared and indicated that, that this bill amendment will now allow workers to respect any federal picket lines that might be set up around the province. Can the minister share with this House what's the breadth or the level of organizations that would be that are currently under the Canadian Labour Code?
Minister.
Clarify his question. I didn't
Chair.
understand the question.
Member.
Yes. So the Federal Labour Code has implications for a number of different organizations and business entities across Canada. The obvious ones come to mind would be our federal ports, maybe federal airports. But through your Honourable Chair to the Minister, can the Minister share with us the breadth of the different organizations that are currently legislated under the Federal Labour Code?
Minister.
Thank you, Honourable Chair. I think that information is easily available if the member chooses to get that. Generally speaking, I don't think I could cover every area of federal jurisdiction when it comes to the labor code or labor law. I mean, generally speaking, banks, interprovincial companies involved in interprovincial businesses, airlines, the water, airports, airlines, I said that, and shipbuilding, I believe, is also TELUS, Canada Post. I mean, those are the some that come to my mind. I remember there may be some other that I'm missing, but it is, it can be easily see what federal jurisdiction encompasses different workplaces. That information is available. We could give you a list maybe later, but I mean, those are the names that come to my mind quickly.
Member.
Thank you, Honourable Chair. Has the Minister undertaken consultation with any of these organizations that will be impacted?
Minister.
Honourable Chair, I answered that question. What consultation took, what guided us to move forward on changing the definition, and my answer stands.
Member.
Thank you, Honourable Chair. Well, I had a quick look over the lunch hour at the number of industries that are actually under the Canadian Labour Code, and it's an extensive list. The Minister mentioned a few: rail, seaports, airports, postal service, telecom, banking, the federal public service, grain elevators, feed and seed mills, feed warehouses, First Nation band councils, and Indigenous self-serving governments, federal Crown corporations, Canada Post Corporation, Port Services, marine shipping, ferries, tunnels, canals, bridges, pipelines, oil and gas sector, international borders, postal and courier services, radio and television broadcasting, railways, some short-line railways, road transportation services, including trucks and buses that cross provincial and international borders, telecom companies, including telephone, internet, cable systems, uranium mining and processing, and atomic energy. Largely any business that is vital or essential or integral to any of the activities undertaken by the federal government. It's an extensive list, and it's very surprising that the minister has not undertaken any consultation with all of these groups and the potential impact that this will have on businesses and even the opportunity for workers that may choose to want to go to work, to earn a paycheck, to satisfy the contractual obligations they have under a collective agreement with their employer, but somehow, just because there may be a federal strike, that somehow those workers are going to be denied the opportunity to cross the picket line and to actually generate a paycheck for their families. Honorable Chair, one of the entities or organizations that I referenced is First Nations. And I know that the current government has made lots of overtures about the need to consult with First Nations. This piece of legislation has a direct impact on First Nations communities and Aboriginal self-governments. Through your Honourable Chair, has the Minister consulted with any First Nations within BC prior to tabling this legislation?
Minister.
A couple of things. Thank you, Honourable Chair. First of all, member had a list of the answer to the question that he asked me, and I just don't know what benefit is there to waste time of this House. Anyway, I think the member also need to know what we are doing here is there may be an exhaustive list here that the member read, but only if they share a common site. And there are not that many. So if federally regulated employees are on the same site as the provincial regulated employees, then if the federally regulated employee are on strike, then the provincially regulated employees will have the right to honor, not other way around. We're not changing anything for the federal laws. We don't have the authority to change federal laws. And so it is only, this will apply to the provincially regulated employees' right to honor a picket line established by provincially regulated employees or federally regulated employees if they're on the same common site.
Member.
Thank you, Honourable Chair. And I was aware of that, but I thank the Minister for bringing that forward. The reason for bringing all of that huge swath and list of organizations and industry sectors that are impacted is that the Minister in his opening remarks had shared that although there might be 500,000 unionized workers under provincial legislation in the province, that very few would be impacted. However, between rails and our seaports and our airports and our postal service, banking, telecom agencies. There's such a huge list of organizations. Should any of those organizations undertake any type of job action or strike action with their federal or their employers under the Canadian Labour Code, those strikes would have a direct and immediate impact on provincially legislated workers. And unlike the provincial labor code, the federal code does not give specific requirements around where strike action can actually be undertaken. Under the provincial legislation, picketing can largely has to be retained at their site of work. That restriction does not exist for federally legislated employers or employees. And so you could essentially see Canada Postal Service going on strike, and you could see picket lines set up pretty much anywhere in the province of BC. Now it would have a significant impact on those 500,000 workers. Look, I appreciate the minister may have concerns with respect to the Labour Board ruling that came out with respect to C-SPAN, but a balance has to be struck between providing that opportunity for a business that has not undertaken any wrongdoing, that has a contractual agreement through a collective agreement with their employees, and not based on that labor piece that exists within that organization or operation, they undertake contractual obligations to provide goods and services, and for their labor force to be upended and go into huge upheaval on account of nothing that was associated with any wrongdoing of the employer, but just because there happens to be another federally legislated workforce on site that has a challenge with their employer. Honorable Chair, I gave reference to the Labour panel hearings that are being undertaken in the province of BC right now, and there have been a number of submissions specifically on this topic. I would hope that the minister has been paying attention to the submissions that are being made, both those that might be in support of this legislation and those that would be opposed to it, to better educate himself. He's admitted or shared that there's been no consultation undertaken at all with impacted business organizations or associations around the province. The panel, which is undertaking work on his behalf right now, is hearing from organizations around British Columbia that I hope would better inform the minister about some of the unintended consequences that have been raised, many of which include C-SPAN as an example. Now, C-SPAN is the organization that was largely associated with the challenge that was brought forward to the Labour Board back in 2022. I'm in receipt of a submission that C-SPAN has made to the Labour panel regarding their Section 3 panel review of Labour Relations Code, dated March 2024. This submission is made on behalf of Vancouver Shipyards, Vancouver Dry Dock, and Victoria Shipyards. I'm going to read this in the record. This is very important information, Madam Chair. We're pleased to make this submission to the Labour Relations Code Review Panel, established under Section 3 of the Labour Relations Code. While the panel has requested submissions on any changes to the code you believe are necessary in order to properly reflect the needs and interests of workers and employers in the context of our modern economic realities, the submission urges the panel to not recommend any changes to the definition of strike in the code as suggested by the provincial government on March 11th, 2024, and Bill 9, 2024. It's the bill that we have before us here today. If passed, the government proposed change to the definition of strike will allow provincially regulated unionized employees to honor picket lines of federal employers or employers from other provinces, and such refusal will not constitute an illegal strike, even if it occurs during the term of a collective agreement. This will reverse the decision of the British Columbia Labour Relations Board in the Vancouver Shipyard case in relation to Canadian Merchant Service Guild strike in 2022. Effectively, this change will allow employees to engage in mid-contract withdrawal of service, a situation the code has historically protected against. It thereby impacts the necessary balance between employees' between the employee's right to associate, unionize, and engage in strike action, and periods of industrial peace. The protection of industrial peace, where withdrawals of services are not permitted, has long been the primary tenet of labour relations in Canada. It goes on to state the purpose of the code is to promote and maintain industrial peace through a fair and equitable collective bargaining regime, which includes the statutory requirement against strikes and lockouts during the term of a collective agreement. The current definition of strike in the code is unique in Canada in that it allows certain employees to engage in mid-contract withdrawal of services. This provides BC trade unions, which are certified to employers with multiple bargaining units, a significant power when negotiating a collective agreement that other trade unions across Canada do not have. But given that the code also has restrictions on picketing, the labour relations balance is maintained as only the employer directly involved in the labour dispute is properly impacted. A change to the definition of strike that would expand the right of certain employees to withdraw their services mid-agreement and affect operations of employers uninvolved in labour dispute will drastically impact BC's ability to attract and retain business. BC is already providing generous protections to employees and trade unions in its labour relations system. This amendment to the definition of strike will expand these rights to unnecessary lengths and will have a significant direct negative and lasting impact on innocent employers and their employees. As we'll more fully explain in the present submission, we are of the view that the definition of strike in the code is an intrinsic component of the British Columbia labour relations regime, founded on the balance of employees' right to bargain collectively and to take collective action, and the predictability of potential work stoppages, which should not be altered without careful consideration as to the entire labour relations regime and its impact on stakeholders. During the fall of 2022, the application of the code with respect to the protection of uninvolved employers from third-party picketing was tested during the strike that involved the Guild and Seaspan Marine. Vancouver Shipyards Co. Ltd. saw its entire operation shut down due to picketing by members of the CMSG, a federal bargaining unit, at Vancouver's shipyard's main place of work. Approximately 1,000 unionized specialized workers of VSY refused to cross the picket line and were without work or pay, which included lost pension contributions for 6 weeks. This created, amongst other disruptions, losses and delays to ongoing projects of the federal shipbuilding program. During the same labour dispute, operations at Vancouver Dry Dock Co. Limited were also shut down due to the CMSG picketing near the entrance of its workplace on the Vancouver waterfront. Approximately 180 unionized workers of VDC refused to cross the picket line and were left without work and pay, which included lost pension contributions for 5 weeks. The shutdown of VDC's operations caused a loss of revenue, a loss of current and future business, and impact VDC's reputation as a reliable ship repair facility.
I realize that you're reading something. Are you reading it in its entirety?
I certainly will.
Okay, with 4 minutes left to go, hopefully there is a question.
There will be a question.
My suggestion is, if this is the whole document, it's 19 pages, and you could easily submit as a document, which would show an answer in its entirety, rather than reading into it. That's a
Yeah.
suggestion.
There is no tabling, but he could pass it to you.
Thank you, Honorable Chair. Look at, time's on the clock. This is really important information. I could try and summarize in my own words, but this is really well written. There's a lot of legalese with respect to this submission, and I think it is important to get it on the public record. Now, I'm just going to carry on, Honorable Chair, and this is not the only submission that I plan on reading into the record today. So maybe we'll get some popcorn for the minister, and he can just be patient. Look, I'm going to go on. During the same labor dispute, operations Vancouver Dry Dock were also shut down due to the CMSCG picketing, which impacted 180 unionized workers. Both VSY and VDC heavily rely on suppliers and contractors to perform work associated with shipbuilding and ship repair. Most of these provincially regulated, and many are unionized. As a result of the shutdowns at VSY and VDC, these external providers were also adversely impacted. The ripple effects of the shutdowns, which were beyond the control of VSY and VDC, were felt by many businesses and their employees. VSY and VDC, while wholly owned by C-SPAN, operate as independent employers engaged in provincial jurisdiction businesses that are vastly distinct from the marine transportation business of C-SPAN Marine, which operates in the federal jurisdiction. VSY and VDC are also not in a position to compel C-SPAN Marine to accept terms or conditions of employment or have any role whatsoever to play in collective bargaining. In this labor dispute, they were innocent bystanders and nonetheless adversely impacted by a conflict they were not involved in. Hence, this caused the uninvolved parties to consider the relief measures available to them to minimize the harmful effect of third-party picketing. I will stress that again. To minimize the harmful effect of third-party picketing, over which they had no control. To that end, VSY applied to the Labour Relations Board for a declaration that employees refusing to cross the CMSG federal picket line were engaging in an illegal strike. VSY argued that its employees were engaging in an illegal strike as they were refusing to cross the federal picket line, not a picket line that was permitted under the code. This argument was based on the definition of strike in the code, which excludes from its definition a cessation of work caused by the employee's refusal to cross the picket line permitted under this code. The LRB initially disagreed with this argument and found that the VSY employees had the right to honor the federal picket line without engaging in a legal strike. On reconsideration, the LRB overturned the original decision and held that the code only protected unionized employees in BC honoring picket lines regulated by the code. In other words, picketing which emanated from a provincially regulated labor dispute. However, the reconsideration came too late, months after the labor dispute had been settled, and well after VSY and VDC experienced the shutdowns described above. Although the LRB reconsideration was of no assistance in this matter, critically it settled the law for future interjurisdictional labor disputes in alignment with the current legislation. Now with that, Honourable Chair.
Member, your time is up now.
Yeah, I'm just going to ask my question.
Well, you should have asked that question within that time frame, so I'll give the opportunity for the minister to answer. And failing that, I'll ask again on clause 57.
Aye.
No, I'm not calling the question. Okay, member, you have
15 more minutes.
Yes, you have 15 minutes, but to ask a question, you have already been reading the letter for quite some time, and it's okay to use it in support of an argument, but there should be a question.
Absolutely.
And so let's avoid the tedious reading of that letter and get to the question.
Thank you very much, Honourable Chair, and I always appreciate your advice. This is not tedious. This is incredibly important information that needs to be read into the record in support of the arguments that I'm bringing forward in questioning the minister. The legislation that is before this House is of significance, great significance, and the company that was directly involved in bringing forward the Labour Code challenge, or the Labour Board challenge, which is the result of this legislation, is before us. So, look, these companies, through no fault of their own, were negatively impacted. Employees couldn't go to work for 6 weeks. The corporation, the company, was behind now on its contractual obligations for contracts it had undertaken with the federal government for the federal shipbuilding program, through no fault of their own. And this is where, Honourable Chair, a balance needs to be struck. The labour laws in this province are already, as the minister has shared with this House, very generous with respect to other provinces in Canada. This specific change will put many businesses across the province at significant risk. And look, what the minister is calling for, to provide the opportunity for provincially legislated workers to follow any strike action undertaken by the federal government. These strike actions undertaken by those businesses that might fall under the federal labor code, it's got nothing to do with the direct operations of those that are under the provincial code. And that is the challenge that we see here, where a small number of workers that go to choose to have a challenge with their employer under the Canadian Labor Code can somehow have a significant impact on the rights of literally thousands of other workers to go to work, to put food on the table for their families. And it's a measure that is premature. There's a labor code review that is being undertaken right now at the direction of the minister. There's many submissions that have been undertaken and made and are still continuing to be made to help better inform the minister, so that when the minister makes a decision or determination on moving forward the legislation, that he's well informed. The minister has shared with this House that there's been no broad consultation around the province with either businesses or other levels of government, First Nations governments, for example, that will be directly impacted by this legislation. Not only are business organizations asking for this piece of legislation to be repealed, but at the very least, to be put on hold until the Labour panel has the opportunity to undertake their work and to provide a report for government's consideration. But that hasn't happened. So, through your Honourable Chair, to the Minister, can the Minister provide any context on where he feels employers' rights are when it comes to being subjected to strike action by their employees when they're fulfilling all of their contractual and collective bargaining agreements with their employees? How is it that somehow the employees should suffer on account of strike action when it's in support of another union that's under the Canadian Labor Code and is in no way connected with the operation or the agreement between those employees and their employer?
Minister.
Thank you, Honorable Chair. I don't need to remind the member, we are living in a democratic society, thanks God. And part of the democratic system is certain rights enjoyed by workers, by employers, by citizens. No one wants to go on strike. No one. It's the last resort that the workers need to, if they feel that they need to engage, to put pressure on their employer to gain a collective agreement bargaining. So then there's a process of picketing. And so they honor each other's picket line. But in BC, a member talk about employer side. Yes, in BC, even under their government, that right existed. That if there was a provincially regulated body located on the same site with another provincially regulated body, if one of them on strike, the other one was allowed to honor the picket line. It was under their government as well. That didn't change. And again, there were picket lines. Even board workers were honoring the picket line that was established by federally regulated employees who were on a same site. But the labor board made a decision, but that would be illegal. But they felt, and many people in HR community always believed, that the workers have a right in British Columbia to honor a picket line. And so how many situations would there be? Very few. We know C-SPAN was one area, and then there was another situation where I think United Steelworkers and IBW was involved. And there may be a few more. I'm not sure exactly how many federally and provincially regulated certification exist on a common site. So the scope is pretty limited. But if that happens, as it happened in those two occasions, it has enormous implications on the workers. Of course, it is always hard on employer as well. Not only just the employer-employee, those are directly involved, but many times there are innocent bystanders who are impacted by the strike actions. Transit, for example, or airlines and others. So, but that's what comes with the democracy and democratic rights. And I wouldn't take any other system. Of course, there are some inconveniences. Of course, there are, there are some pains caused to many people who are not even directly involved. But that's what's allowed under our Constitution and our democratic system. So, like I said before, workers do not want to go on strike. I've been there. And it was heart-wrenching debates you go through when you decide to go on strike. And because you felt that's the last resort, that you have to resort to that action. Because they know what you lose during the strike, you may never recover. But those are the decisions that the workers make. Because not only for themselves, but the workers coming behind them. And so I share the concern, but at the same time, I say that the workers take this issue very, very seriously. They don't like to picket, but if they have to, they will. And again, the member may want to leave an impression somehow that there's strikes all over the places, and it's impacting a lot of employers out there. I don't have the recent numbers, but I can tell you very few, maybe less than 5% of labor involved in bargaining, less than 5% ended up in any disruption, Canada-wide. And most of them, 95, 97%, are resolved without any interruption. So system works. And, but those 2 or 3%, of course, leave a lot of, you know, a lot of inconvenience, you know, for those workers, for employer, and maybe other people around them. So the other part I want to mention here, member is reading into submissions that are made to the Labor Board review panel. But that's not just the one submission. There are a number of them. Who, you know, the people are making those submissions. There will be similar submission probably from the labor side, opposing everything that is being read into record here, making argument in favor of what we are doing here. I haven't read them all, but that's what happens in a democratic system. Workers individually are making submissions. Organized labor is making submissions. Individual employers are making submissions. Organized employer are making submissions. Academics are making submissions. And at the end of the day, I don't think it's any helpful to read one submission into record, because there will be so many submissions going to the review panel, and then they will consider all of them and come back with a recommendation. That is the right thing to do. I think it's a bit just disingenuous, in my view, to read one submission. Unless the member wants to go on and read every submission that comes to the panel, not sure where that would take them, whether that would be the best time to use this House. So I think we should allow these submissions to go in. Panel would consider all of them and come back with the review. After reviewing it, come back with the recommendations. We will make a decision at that time. Not only just one issue, but there will be a whole lot of other issues that they will hear from the community out there. So I think it's, in my view, it's appalling that the member read one submission. Unless he wants to read all of them, he should say so, because there are so many, and then only you could do justice. And with that, Madam Chair, I'm lost. What the purpose is here for reading into record one submission? I mean, I could understand if the member was going from one to another, using some examples that this is the kind of submissions that are coming in, and I get that. But those submissions are for the panel's review. They are the one who would be considering all submissions and making a recommendation based on that. So with that, Madam Chair, it's their time, and if they want to waste, this House's time by playing these silly games, it's up to him.
Member.
Well, thank you very much, Honourable Chair. Well, what do we hear from the Minister? Silly games, appalling, and disingenuous. Look, what I believe is disingenuous is having a Labour panel go out and consult British Columbians to hear and to learn about what is happening on the ground across the province, and for that panel to assemble all of that information and present a report to the Minister for consideration. But while that work is underway, the Minister has chosen to kneecap the committee and move forward with a piece of legislation that the panel's hearing about directly. That's disingenuous. There's no games being played by this side of the House. The games that we're seeing is a minister that has moved forward by tabling a very important piece of legislation in a miscellaneous stats bill. And certainly this government, they have the prerogative, they've got the votes. I'm quite sure that this will likely pass. But the high-handed manner by which the government is acting. That is what is truly offensive, Madam Chair. Look, these submissions are valid. These are real concerns from businesses that are operating across the province, from business organizations that are representing tens, hundreds of thousands of workers across BC. When we talk about the ability for provincially legislated workers under the BC Labour Code to now, under this legislative change, to honor and respect picketing that's undertaken by those that are under the Canadian Labour Code, that's very, very different. Items like the location of picketing is very well defined under the provincial Labour Code. It is not defined and does not have those restrictions under the Canadian Labour Code. Railways. Railways touch just about every large industrial site in the province. And if there was a strike by any of our federally regulated railways, it could impact and strike. Picket lines could be set up literally at every industrial site in this province, including our ports. We saw that the 13-day strike at our ports last year cost British Columbians, reduced our GDP by I believe $1.6 billion. Other businesses were directly impacted by that. The breadth of this change is very distinct and different from what currently exists in this province. So, Honourable Chair, from the Minister to try and accuse the opposition of playing silly games, this is important information. This is a legislative change that has serious consequences. The Minister has not undertaken any broad consultation to even inform himself about the potential implications. What would happen should our railways go on strike? Does that mean that any rail line that has a spur going into a cement plant, that suddenly workers could set up a strike there? Yes, they can, because the Canadian Labour Code does not restrict the location where picket lines can be set up. So we got a busy construction season, and suddenly we see cement plants with job action, and now our construction sectors put it at standstill. Canadian postal workers, they could set up strikes pretty much anywhere in the province of BC. And I'm certainly not suggesting that we're going to see this huge ramp up of strike action across the province, but this change is incredibly important and can have negative consequences, not just on those businesses that might be cohabitating on a specific site, but what about businesses that are looking for supply chain assurance that those products and goods and services they might rely on for their businesses are going to continue to flow? It's already been noted a number of times that what the Minister is proposing is not consistent with any other jurisdiction in Canada. Business associations are bringing forward significant concerns. The Canadian Federation of Independent Business.
Member, are you going to read that?
I'm going to read some sections of this, to help support my question, Madam Chair.
Unless the member can demonstrate the relevance, it is not
It
clear
is.
to the chair how that letter is relevant. So if you could pose your question and then get to that.
Okay, well, absolutely. So through you, Honourable Chair, this bill, this piece of legislation, has the potential of having significant harm to the economic well-being of many businesses across BC. The Canadian Federation of Business, it's a non-profit, non-partisan business association with 97,000 members across Canada and 9,500 members here in BC, representing hundreds of thousands of workers. We're Canada's largest organization exclusively representing the interests of small and medium-sized businesses from a variety.
The question, please. So, and
Honourable
then you
Chair,
can go to that.
are you, Honourable Chair, just looking for some clarification. Are you of the opinion that I'm unable to read any submissions onto the record here today?
Member, I'm asking for your assistance to help understand the relevance of what you wish
Thank you
to
very
read.
much, Honourable Chair.
So the question is going to help guide me.
Yeah, the question will come at the end of.
I appreciate hearing it now.
Honourable Chair, I certainly do appreciate your advice, and I don't want to have a quarrel with you. However, I do have time on the clock. Part of the reason and the opportunity for me to raise a question is to provide supporting arguments, and these supporting arguments are coming from business organizations representing hundreds of thousands of workers across the province. I am their only conduit to the minister as part of this debate. So I certainly hope that you'll provide me and grant me with a little bit of a leniency as I attempt to try and present a well-founded argument to the minister and trying to better understand the reason and rationale for the legislation that's before us. So the CFIB participated in the 2018 review, and we're pleased to share their members' perspective again on the 2024 Labour Relations Code review. The following submission outlines CFIB's concerns regarding the compressed timeline for the review process, as well as the lack of information on what amendments are being considered by the review panel. The letter goes on to include the submission also argues for the reinstatement of the secret ballot vote for union certification. But the specific part of this letter, Honourable Chair, that is directly related to the legislation before us is with respect to secondary picketing. And the CFIB, in their submission state, we are concerned to hear rumors that the panel is considering eliminating current secondary picketing restrictions in the code. While CFIB recognizes the importance of the right to strike, secondary picketing has harmful, unfair consequences for BC's business community and the economy. Secondary site picketing is a tactic where strikers or striking workers picket at a location other than their own workplace, which is often a third-party business that may or not be connected to the employer involved in the dispute. These third-party businesses endure unwarranted reputational damage, disruptions to their regular operations, and financial fallout due to secondary picketing disruptions. They also may need to spend more time on increased security and shoulder red tape burdens to ensure their actions are legally compliant. This tactic is incredibly unfair to these third-party businesses that are not at fault, yet are forced to suffer consequences. They pose the question, why would the code allow workers to punish uninvolved small businesses that have done no wrong? It goes on to state, secondary picketing also increases the economic impacts of strikes. Small businesses rely on the goods and services of other businesses, and if a supplier is being picketed, this can drastically disrupt supply chains. Supply chain disruptions lead to delays, shortages, and higher costs for small businesses that ultimately translate to higher costs for consumers. Once a strike ends, it doesn't guarantee business will resume as usual. The practice of secondary picketing can strain or damage the relationship between the primary employer and the affected third-party business. It can also affect relationships with customers, suppliers, investors, and other stakeholders, potentially leading to long-term damage to business relations and local economies. As previously noted, the Code Amendment, Bill 9, will allow for an expansion of secondary picketing and specifically for picketing to impact uninvolved businesses. The amendment means federal pickets can now effectively shut down provincial employers, and that provincial employers will have no recourse to address the impact of the federal picket line. This change is being made without consideration for balance in employment relations or the fact that this amendment is inconsistent with the Section 2 duty that requires the board to apply the code in a way that minimizes the effects of labor code disputes on persons who are not involved in those disputes. Ultimately, the provincial employers should not face the challenges of secondary picketing or risk being shut down by an unrelated federal labor dispute. BC residents and businesses have already felt the wide-scale impacts of major labor strikes during the 13-day Vancouver port strike this past summer. The Vancouver Board of Trade's port shutdown calculator estimate the value of the trade disputed over the course of the strike was an amazing $10 billion. Of course, this massive figure does not account for the reputational damage done on a national level to Canada's reliability as a trading partner. Businesses across BC and the rest of the country struggled with supply chain impacts and lost revenue from delayed inventory, while residents struggled to acquire essential products like medication and baby formula. The massive repercussions of the strike live in the recent memory of Canadians who served as a reminder to ensure that when possible, strike activities do not escalate to a point of economic and social harm. In summary, removing restrictions on secondary picketing in the code will harm businesses and consumers, while providing little benefit to employment relations. We strongly recommend that the Labour Code Review Panel advises the government against lifting restrictions on secondary picketing because it will unfairly burden uninvolved third parties, broaden the devastating impact of strikes, and further undermine BC's reliability as a trading partner. Now, with that setting the stage, through your Honourable Chair, has the Minister undertaken any form of economic review to determine what the potential cost may be associated with the legislation before the House?
Minister.
Thank you, Honourable Chair. The member read again a submission to the panel, Labour Code Review Panel, and the question was not even close to what the submission talked about. I mean, the submission did talk about secondary picketing and what the panel should consider and recommend. And that's up to the panel. I don't know what purpose it serves for the member to read it here. It goes out there to the panel, and the panel certainly, I applaud the businesses and the unions and others to make those submissions, because that's where they should be making those submissions. Now, to answer, I could try see how close we are to what the member's question was. How many federally regular employees have been on strike across Canada? I have that information. 2014, 5. Across Canada. 2015, 12. 16, 3. 2017, 6. 2018, 10. 2019, 9. 2020, 2. 2021, 3, 22, 10, and up to October 2023, 8. So then if you break it down further, how many of them are in British Columbia? Out of 2 or 3 or 5 maybe? And then how many are co-locating with the provincially regulated employees? I think the answer would be very, very small numbers if they ever end up in strike, because that's what the strike and the labor dispute numbers reflect here. So problem may not be as big as the member suggests, but certainly the submission that are going to the Labor Code Review Panel, I'm happy that they are making those submissions and making those arguments on behalf of their organizations, and the Labor Code Review Panel will be considering all those submissions, and they will be making a decision later this year, and then we will go from there.
Member, I see you have another submission in your hand, and once again, I ask that you assist me to understand the relevance of the submission by giving your question first.
Thank you, Honourable Chair. I do appreciate your advice. Look, through your Honourable Chair to the Minister referenced some very low numbers. We know that in 2022, just in the case of Vancouver shipyards, there was a very few number of federally regulated workers, but their impact was much more broad. Although there's only a few tugboat operators that were actually part of taking strike action against their employer, there was over 1,000 workers that couldn't go to work. And just for those that might be listening from home, if there's strike action, those employees are ineligible for any employment insurance benefits. They may be entitled to strike pay, but as we know with the United Steelworkers on Vancouver Island, they were only provided 1 day of strike pay every 2 weeks. I remember being on the front steps of the Legislature talking to workers that were tied into that strike, which went on for, I believe, over 8 months. One gentleman in tears. He said he couldn't find alternative employment. He lost his house. His spouse left him. He was devastated. Now that was a strike action that I think netted them 12.5% wage increases over 4 years. But I don't have no quarrel with that. That is the current laws that affect the BC Labor Code. And there is an opportunity for both employers and employees that are outside of a collective agreement. Job action, strikes, and picket lines is one of the options that's available to them. I have no quarrel with that. But what we're looking at here is to give an additional opportunity for any federally regulated worker the right to negatively impact BC companies. They don't have to cohabitate. That is definitely the case with respect to Vancouver shipyards. They did happen to co-locate on the same location, but that is not a requirement because the Federal Labor Code does not restrict where picket lines can be set up. You only have to look at our pipelines, on our rail lines, and our ports and our seaports to have a look at the significant impact a very few subset of workers that might have a quarrel with their employer under the Canada Labor Code can have far-reaching negative impacts over workers that are in the midst of a collective agreement with no quarrel with their employer. Where is the fairness in that? And that is what the core concerns are that have been raised by all of these different business organizations representing thousands of companies and hundreds of thousands of workers across BC. Not just the unionized workers, but also other private sector workers that are negatively impacted because of supply chain challenges. There is likely a reason why all other provincial or provinces across Canada have not gone so far as what the minister is proposing. And with this piece of legislation coming forward at the same time that a democratic process is unfolding, a process by which this minister actually brought forward to provide an opportunity for the Labour panel to go out and consult British Columbians and to get well informed and to assemble all of that information and provide some advice and recommendations to government for their consideration. But while that work is undergoing, the minister kneecaps them and drops forward this piece of legislation which is out of step with every other jurisdiction in Canada. And that is the concern. Through your Honourable Chair to the Minister, does the Minister feel that it is fair and just for maybe as few as 2 federally legislated workers to potentially set up a picket line and negatively impact thousands of workers from going to work?
Minister.
Thank you, Honourable Chair. I think we debated this issue, why we are doing this, quite a few times now. And it is a basic fundamental right that the workers enjoyed in British Columbia, that not only that they honor a picket line set up by themselves, but also other provincially regulated employees, that they have the right to honor that picket line. That's what we have in British Columbia since 1970s. Didn't get changed even during the 16 years that the Members' Party was in government. Is it fair? I mean, that's the question that maybe he should ask himself. And but it is a basic fundamental rights that the workers enjoy. Picket line is a picket line is a picket line. That's what the workers and many people in HR will tell you. And I think it is the only tool, in my view, that the workers have to make sure that they get their fair share at the bargaining table. And there are people who get inconvenienced by that. We all remember a transit strike. One union, their employees were on strike, and they had a picket line that impacted another 4,000 or 5,000 who refused to cross their picket line. That's democracy. And I wonder if the member opposite somehow have questions about democracy and democratic rights that workers have. And that's how it works. And you can't pick and choose the values of democratic system. Either you have it or you don't. People die and kill out there to have a democratic system. And I can tell you, the union movement is very, very responsible. They know how difficult it is when they call their members to go on strike. They know if they go and pick another site, how difficult it is. And they don't take those things lightly. That's why the labor disputes all across Canada are very small in numbers and over time. And so I think I am confident that the labor movement is quite capable in understanding their responsibilities to their members and to other union members. And they don't take these things lightly. They don't just willy-nilly throw picket lines. And what we are doing here is clarifying the question that has been raised by the Labor Board decision recently, because during previous government's times, labor movement, the workers, threw picket line and honor picket lines from other jurisdictions. But they were challenged at C-SPAN. C-SPAN decided to go to the Labor Board, and the decision came against the workers. So I think member can, I'm sure where he stands when it comes to labor rights. I'm sure he knows, him and his party stands when it comes to workers' rights. And although he used the word workers, somehow that he's representing wishes of some workers, he clearly does not. It's their representative who have a sole responsibility of representing those members. It's those representative of those workers who were impacted and who were involved in these disputes are saying, look, we need to have the definition of picket line defined properly. And that's what we're trying to do.
Member.
Thank you, Honourable Chair. I didn't hear a response or an answer to the question. And I think that, if we look at the issue at C-SPAN and Vancouver shipyards as an example, a few workers, tugboat operators under the Canadian Labour Code, choose to picket and deny the opportunity for over 1,000 individuals to go to work for 6 weeks and put a paycheck on the table for their family. There is no benefit to those 1,000 workers by not going to work. They weren't in any contractual negotiations with their employer. They weren't fighting for higher wages or more benefits. They're an unrelated third party. 1,000 workers couldn't go to work for 6 weeks. And I don't know if you, Minister, but most families, if you lose a paycheck for 6 weeks, it's going to hurt. There is no benefit for those workers. No benefit whatsoever would fall onto those workers. They weren't negotiating for wages. They had a collective agreement that was signed and duly undertaken between the unions and the organization that they were working for. Where is the benefit? Certainly no benefit to the employer, who had no source of revenue, and probably, I don't know what they did with 1,000 workers not showing up on the job site for 6 weeks. They're hugely disadvantaged. And to those workers, what benefit flowed to them? They didn't get EI benefits. They might have got what? Maybe a day or two of strike pay? How does that pay the bills? So where is the benefit? This is what I don't see. And this is the challenge. The workers that are under the Canada Labour Code can picket anywhere. They have freedom to set up picket lines wherever they choose across the province. As few as 2 workers could choose to have an argument with their employer and set up a picket line, potentially impacting thousands of other workers. That's not fair. That's not just. That's not reasonable. Yet, that is exactly what this bill potentially will allow. There's concerns about some of the railway workers on what might happen during the month of May. And maybe the minister's not concerned, but if we have supply chain disruption with respect to our rail lines, the manufacturing sector is going to suffer. There's many other businesses that are going to suffer. And in order to try and strike maybe a better deal with their employer, if those workers choose to start setting up pickets at sidings going into pulp mills or sawmills or cement plants, we could have significant labor disruption. And that should be of great concern. There's a balance that has to be struck in this province. And what the minister is undertaking with this piece of legislation is out of step with any other jurisdiction in Canada. You know, quite often, we certainly will hear the minister compare how we're doing here in British Columbia compared to other provinces. But in this instance, there must be a reason why other provinces and jurisdictions across Canada have not gone so far as to move forward with legislation the way the minister is intended. And there has been no consultation. Look, a government has an obligation to make decisions that are in best interests of everyone in British Columbia. And I certainly appreciate that there's been some significant undertaking to provide additional supports and protections, in his view, for unionized workers. But unionized workers are not the only workers in British Columbia. There's many others in the private sector that could potentially be negatively impacted. And we only have to look to last year's federal port strike, which had supply chain difficulty and negatively impacted many business operations across British Columbia. So, Madam Chair, I do appreciate your leniency in allowing me to share some of these business concerns that have been brought forward by many different business organizations. And it's not me. You know, the minister can certainly look to me and say that, oh, well, the member, he has these views. I'm just a conduit. You know, as much as the minister might represent unionized labor, there's also lots of private sector organizations across the province and many other business organizations. You know, I referenced CFIB as one, but, you know, Vancouver Board of Trade, the Business Council of BC, the BC Chambers. These organizations are also concerned. And has the minister reached out to connect with them, to have a conversation, provide them any assurances? No, nothing, zero, not even First Nations, which this minister has indicated this government has an absolute duty to consult with. First Nations are directly impacted by this legislation, and the minister has not consulted with First Nations. Maybe through you, Honourable Chair, to the minister. Has the minister even provided a copy of the legislation to any of the 204 First Nations around the province, or undertaken even any direct consultation with any of the organizations representing First Nations in BC?
Minister.
Before I answer the question, Madam Speaker, the member is very clear since we started this debate on Bill 9 today. He is repetitive and repetitive and repetitive, making the same argument over and over and over again why the direction we are going with the Section 57 here is wrong. He's on record. I don't know what purpose it will serve for him to keep on repeating that. So I would ask your guidance on that and guide the member to perhaps get back into the body of the bill itself, because he hasn't asked one question about the definition of person, strike. That's what's in the bill, and he has already made a very clear argument why he does not support this. At second stage, he made the same arguments he's making here for the last number of hours. Same thing over and over, nothing new. But he did mention whether we met with anybody since the introduction of the bill. I did meet with business leaders, and they raised their concerns, and I assured them that they have every right to present their arguments to the Labour Code Review Panel, and so they would do that, and in fact that they are doing it. And as far as who I sent this the copy of the bill. It's available online. No, I have not sent it to the First Nations.
Member,
Thank you, Honourable Chair. Can the Minister share which business leaders the Minister met with and when?
Minister.
It was,
I'll have to look up the when.
yeah, Business Council of BC and Greater Vancouver Board of Trade. It was online meeting that we held. It happened within last 2 or 3 weeks, I believe. But I could get the exact date if the member really wants the date.
Member.
Thank you, Honourable Chair. And was that meeting specifically related to Bill 9, or was it in relation to other inquiries?
It was in
Minister.
relation to Bill 9.
On clause 57. So ordered. Oh, on the title? So ordered. Minister.
Honourable Chair, I move that the committee rise and report the bill complete without amendment.
Members, the question is that the committee rise and report Bill number 9, complete without amendment. Those in favor indicate aye. Aye. Opposed? The motion is carried. The committee stands adjourned. Good afternoon, members. I call Committee of the Whole on Bill number 3, the Budget Measures Implementation Act 2024 to order. Shall Clause 1 pass? Recognizing the member from Kamloops, North Thompson.
Sorry, before I jumped in with questions, I wasn't sure if the minister wanted to do an introduction or anything, or no, just jump straight in? Okay. That's fine. Obviously with clause 1, it's around just changing the date of the, well, it's not just changing, but it's got significant ramifications. The Balanced Budget and Ministerial Accountability Act changing the date, amending it from 25-26 and substituting 26-27. Budget transparency is fairly important, and so I'm just wondering today, this is an election year. It sounds like the first quarter update won't be until September 15th, possibly, but the government also has the ability to not provide a first quarter update. Given the size of the deficit that we see in this year's budget and the changing of the date out further in terms of the budget balance dates, is there a commitment from the government that we'll actually see a first quarter update this year before the writ is called?
Minister.
Thank you, Chair, and I'll just quickly introduce the folks that are with me for this section. Doug Foster, ADM of Finance, Finis Pernecki, Executive Director of Treasury Board staff, Chris Ferguson-Martin, Legal Counsel, AG, and Alexander Banford, Executive Lead on for Indigenous Inclusion. So by law, we have to present the first quarter by September 15th. So we will be presenting the first quarter before, either on or before September 15th.
Member.
Thank you. Well, I understand that technically that is what's supposed to happen. There has been other instances in recent history where the minister delayed one of the quarterly updates. I believe the minister was sick, and that's understandable, and that's part of life. And so my understanding, though, is that under the Budget Transparency and Accountability Act, I believe it's section 10, I can't remember the subsection off the top of my head, maybe subsection 3, there actually is a provision in an election year that the government can, when the public accounts are going to come up against a writ period, choose to not actually present public accounts. Is the minister saying either that clause is no longer relevant or that it can't be actioned by this government?
Minister.
Yeah, just for the record, I will clarify that the minister did have COVID, and she didn't think anybody else would want to have COVID either. So that's why it was delayed this last year. The law says that it has to be done by the September 15th. The exception is if September 15th fell after the writ had been dropped, but it's before the writ has been dropped.
Member.
Thank you. I'll find the exact section and come back to that. I'll have a different question on this same section. So this is pushing out a potential of a balanced budget from 25-26 and substituting 26-27. Is the minister saying that is the date this government has committed to, no longer having a deficit, or is that it's just a placeholder and there's not an intention to be back to balanced budgets?
Minister.
Thank you, Chair, and we pushed it out to 26, 27 because this is a 3-year fiscal plan that goes to 26, 27, and we will discuss balanced budgets when we get to the right time.
Member.
Thank you. So back to the date of public accounts release of the first quarter results. Is the minister committing today that they will not be invoking the Budget Transparency and Accountability Act, Section 10, subsection 5, which actually does allow for the government to not present a first quarter update in an election year, given that the window under that section of time is too close to the election if the government wants to deem it that?
Minister.
Thank you, Madam Chair. Maybe there's a different interpretation of the law, but what we have here says the quarterly report would have been required to be made public on or before a date that is within the period that A, begins on the date a general election is called. So the general election will be called after the 15th. So we will be presenting the Q1 prior to, we have up until September 15th to present.
Member.
Thank you. My understanding is, and perhaps I'm got my dates wrong with Elections BC, my understanding is the window of time with an October 19th general election set in is that it's anywhere from September 14th to September 22nd, I believe, is the date range that an election could actually be called, given that they have 28 to 34 days to have a general election. It's based on which days the Tuesday in a calendar is, but it's also at the discretion to have that latitude. So I guess the worry out there is there's a ton of commitments being made by government after the budget on very large projects, Olympic Village School being one, the Cancer Centre in Kamloops being another, others that are being pushed off to the first quarter update report that would come out, which is a natural course of business in a normal year. I understand that because they're all projects over $50 million. But with the 15th being the release date, and the potential of, as my understanding of the 14th being the potential first day of a writ period, that would open the door that we would not actually see a release of public accounts publicly. They may be finished, but they won't necessarily be released publicly. Is the minister amenable to a few day earlier date than the September 15th being the one carved in law versus the one that they commit to as the ministry to release public accounts to the public and so people can see the state of the finances of the province of British Columbia?
Minister.
Thank you, Madam Chair. So the writ date,
Minister, sorry that we're not allowed to use electronic devices
Oh.
when you have the floor. So
can I just look at it? Okay, so thank you, Madam Chair. Sorry about that. It's not mine. Does that make it better? But anyway, so the writ date, according to Elections BC, is September 21st. Election day is October 19th. I think we all remember that. September 15th is the end date to be able to present the Q1. September 15th is before September 21st, the writ day. So that's the law.
shall Clause 1 pass? Aye. So ordered. Shall Clause 2 pass on Clause 2? Member.
Thank you. And so this is the setting up of the First Nations Equity Financing Special Account and the clauses around that. I'm just wondering if the minister can shed some light on how the initial 10 million and then by extension the 200 million in the following years will happen. I've had some questions and I couldn't answer. So is it that the projects are 10 million or 200 million, or is it meant that this is the amount of money available to pay the financing costs of acquiring an equity stake in types of projects out there?
Minister.
Thank you, Madam Chair. So the $10 million inaugural balance is going to be to help to support immediate capacity needs for those First Nations that are actively considering equity participation in priority projects. So it's an inaugural balance. What the member's referring to, I think, is the 200 million that was in the budget. It was on a chart. It was a hypothetical illustration of the potential provincial loan guarantees over the next 5 years, assuming that 200 million of new First Nations equity loan is guaranteed each year. And just to remind the member that these are loans that First Nations will go and get from individual banks or financial institutions, and the nations will be responsible for paying the servicing debt on those loans. We just, as a government, will backstop them.
Member.
Thank you. I guess seeking further clarification, though, is the intent to backstop. In other words, is the government intending to backstop $200 million worth of projects or $200 million worth of borrowing costs? In other words, potentially billions of dollars worth of projects that have a $200 million carrying cost to them, or is it that it's capped at $200 million of an actual project value spread out over various First Nations?
Minister.
Thank you, Madam Chair. So it's important to know that we're not backstopping projects. We're backstopping First Nations to obtain loans from financial institutions. We are guaranteeing that if the First Nations default, then we will support the financial institutions by supporting the payback of the loans. And it's important to acknowledge that it's the First Nations are obtaining loans to obtain equity interest in projects in the province.
Member.
Thank you. I understand the backstopping part. I'm trying to get to what is the exposure for the government and the potential overall value that the government's anticipating these projects to have. We have 204 First Nations in the province, so at $200 million a year, that would be $1 million project per nation for the next 5 years. not exactly earth-shattering stuff when you're talking energy projects? Or is it that it's backstopping the payment? So in other words, if you had a $500,000 mortgage on a house, it's about $36,000 a year of a mortgage payment. It's a big difference to the risk to the government, I guess. So I'm trying to figure out, is the 200 million being leveraged to create, you know, billions of dollars worth of investment in the province, or is it strictly that you're saying that First Nations can go out and borrow $200 million for equity, up to $200 million worth of equity stake in projects, and you will guarantee the 200 million, and that's the full exposure of the province. In other words, there's no added value to that 200 million. It's strictly a $200 million worth of value. I hope, at least the staff, I get the minister might be a little confused of where I'm going with this, hoping the staff understand it. It's just, it's not meant to be a gotcha question. I'm trying to understand the scope and the scale that First Nations should reasonably be able to expect of projects that they will be able to try to access and leverage with the government backstopping them with a $200 million a year figure out there.
Minister.
Okay, thank you, Madam Chair. So first off, I just wanted to clarify for the member that there's actually $1 billion cap on the amount of and it has a cumulative total on the requests, and that be set in regulation. So one thing to clarify is what First Nations are looking at when they apply for this is an equity interest in the project. So they wouldn't be, so they are going into a collaboration partnership with other people. So for instance, if they're looking at $100 million mining project and they want an equity of that project, they might want to borrow 20 million and get that equity share out of it. So it's to ensure that they can get into equity into projects in the province. We could get so the amount of the loan, the equity would just be the First Nations portion of the loan. So we would be looking at 20 million in that instance. And also if a First Nation wanted to be a sole owner, that would have to be a discussion, because this is about equity in projects that they have partnership in. Oh.
Minister.
And I move that the committee rise, report progress, and ask leave to sit again.
Members, the question is that the committee rise, report progress, and seek leave to sit again. Those in favor indicate aye. Aye. Opposed? This motion is carried. The committee stands adjourned.